State of Kansas v. Adam Ardry.
May it please the Court, Patrick Dunn, Deputy Appellate Defender, appearing today on behalf of Adam Ardry. May I please have 3 minutes for rebuttal?
3 minutes is granted.
Mr. Ardry entered a plea to aggravated indecent liberties with a child, and this was pre-Jessica's law, so he was still subject to the guidelines at that point in time. The District Court found some agreed-upon substantial and compelling reasons submitted by both the state and defense counsel, granted a dispositional departure to 36 months probation, and announced an underlying 216-month prison term, which was the mid-number of grid box 3B. Unfortunately, probation didn't work out completely perfectly for Mr. Ardry, and he was called back for violations. At the conclusion, the district court ultimately elected not to reinstate probation, and what we're here today on is basically what can the district court do after revoking probation. And it's our contention that under the plain language of 223716, which is the specific statute covering probation revocations, the district court is free to do exactly what the statute says. The plain language of the statute says the district court may continue to revoke probation, assignment to community corrections, service program, suspension of sentence, or non-prison sanction, and may require the defendant to serve the sentence imposed or any lesser sentence. Now the question is, did the legislature mean what it said? Or are there extraneous restrictions outside that specific statute? It's our position that the plain language of the statute controls. Justice McFarland pretty much stated that much in State v. McGill, and the Court of Appeals, which was cited with approval in Abasolo, specifically said there's no extra restrictions upon the district court. Any lesser sentence means any lesser sentence. Now, it's our position basically that the rules under the guidelines governing departures are limited to sentencing. Probation revocation is not sentencing. This court said that there's special rules once you get beyond sentencing and you are now at probation revocation. It's a separate proceeding. In a case that I had when I tried to argue about bids fees a couple of years ago, I was told that no, that's sentencing is when bids fees go in. It's a different animal, and there's a policy reason behind that too. And I think the legislatures recognized that by not changing that statute. At the time of the probation revocation in this case, the 223716 had been amended not less than 5 times since the imposition of the guidelines. If the legislature, and this was after McGill also, if the legislature had wanted to impose conditions following McGill or Hall, when Hall said that no, there are no restrictions requiring substantial compelling reasons, then the legislature could have done that post-Hall. Hall was a 2002 case. 223716, that, again, I said, been amended several times. Had the legislature wanted to change that, they could have, and they didn't.
The problem here, as you see it, is in imposing any lesser sentence. The trial court believed that he had to use some sort of departure factors, and that he had to further distinguish between a dispositional departure that he's already granted and a durational departure in order to do that. Is that your understanding of what occurred?
Which is wrong for a bunch of different reasons.
Yeah, that's right. That may be wrong, or you can argue that. But the problem here is that even if there's language that the court used when he reimposed sentence that said that could that you could understand to be that it didn't matter whether there were substantial and compelling reasons for departure or not. He's not going to depart. Or he's not going to depart. He's not going to impose a lesser sentence.
I don't believe that's. I think that's subject to interpretation. There, he said.
Well, he said, I couldn't really have any substantial and compelling to reduce the sentence, and if it did, it would have to be different. And if it did, it seems to me that he's just saying, I don't have any reasons to even consider a modification.
Substantial and compelling reasons is what he said.
I don't have it. Yeah, I don't have any substantial and compelling reasons.
Now,
well, what does that mean?
First of all, there's a couple of different reasons why there's a problem with that. First of all, even if you were to take the state's interpretation requiring substantial and compelling reasons, you can still give the mitigated number in the box. And that the dissent pointed that out in the Court of Appeals. So right there, the district court was misinterpreting the law that was applicable to it at the time. That's an abuse of discretion, using the wrong law when exercising your discretion. So right there, we have error there, subject to resentencing. Now, backing up to the more fundamental problem, we contend there is no reason to, well, second of all, I guess, stepping back one step before that, you don't have to have different reasons for a durational and dispositional departure if you're going down. The statute 2147-19, I believe it is, that addresses something similar is when you have a dispositional departure to prison. If you want to go above that durationally, you have to have additional substantial compelling reasons. And the case law hasn't been cited in previously, so I'm not going to mention it, but the case law is out there that says no. It's case law from this court that's long-standing, 15 plus years old. No, you don't. The statute specifically says only in the case of a double up, for lack of a better term.
Counsel, are there any limitations on what the revoking judge can do as long as it's a lesser sentence?
I think, I guess the only limitation would be whether or not it's an abuse of discretion. And in that case, no reasonable person would agree with what the judge had said. That's what an abuse of discretion standard is. It's a judgment, and presumably it could be appealed.
My understanding is something you said earlier, according to my notes, is that probation revocation is not sentencing. Therefore, the KSGA is inapplicable here. Is that a fair statement
Yes.
of what you said?
Yes.
So would the judge, as long as the sentence was lesser, was there any KSGA application or restriction on the judge?
As far as downward, no.
Could the judge go back to pre-KSGA sentences and order an indeterminate sentence?
And as long as it's a lesser sentence, possibly, I guess so. I want to also point out that if you look at the departure statute and the regular guideline statute, 4704 coupled with 4716, both statutes say the sentencing judge has to state on the record at the time of sentencing what the departure grounds are. How can a judge at a probation revocation hearing go back to substantial compelling reasons that happened before if they happened later? I guess, and I probably inarticulately explained what I was trying to say. The reason I think it's clear why 2237-16 allows a lesser sentence is it's a simple policy matter. The judge should be able to evaluate what happened after sentencing through probation. Some probationers walk out the door and go out and smoke crack the next day. Clearly, they're not going to do well on probation. Yet you have other probationers that they do all their treatment, do all their community service, pay all their costs, pay restitution, and they miss the last appointment that they have at, say, month 23, day 25 of a 24-month probation. They missed one very technical thing. Now, technically, they violated their probation. Is the judge is required to give them the full sentence that they originally imposed? And no, the legislature didn't intend that. The legislature intended the judge to be able to exercise their discretion and say, you did well, we really don't need to send people to prison who aren't dangerous and who have pretty much gotten everything. It was one tiny little thing. No, we'll give you a small jail sanction over that.
So basically what you're saying is at the probation revocation stage, any lesser sentence gives, at least in terms of imposing a lesser sentence, the trial judge just unbridled discretion.
Not unbridled. Again, I said before,
in this case, we have a 20-year sentence, almost. He could have said, time served, you're done.
And I think the state would have jumped up and appealed, and I think we would have had like Haney or Ardry, which are long time ago cases out of Douglas County where there was a rape where a particular judge there imposed probation, and the court said, no, that was an abuse of discretion.
My point is that if in a probation revocation that occurred, or that occurred at sentencing?
One was following a probation revocation. I don't recall which, and these aren't cases I talked about because this wasn't something we were talking about below.
But my point is that's your point, is that any lesser sentence means anything.
And again, subject to the review for an abuse of discretion.
Wasn't that the point of this court in McKnight? We upheld the ability of the district court to impose an illegal sentence, one without post-release. And if we're going to allow a lesser, even if it's illegal, then there really is no governor on this engine other than abuse of discretion, it appears to me.
I suppose that's fair to say, yeah. And I'm running short on time, so I'll try and run back through to see what points I hadn't touched on that I wanted to. Really, the state's reliance is really just on dicta in Abasolo. Abasolo didn't have to do with a sentence that was below presumptive sentence. So any language to the contrary, I don't think is really binding on the court. I think, as was noted by Justice McFarland and McGill, the plain language of the statute, again, I'm reiterating here, hasn't changed despite the inclusion of the guideline, and there were significant changes in 2000. Other cases have come down. Hall's come down since. The legislature's had the opportunity. We have to go with the intent of the law. If the legislature had wanted to change it, they could have. They didn't. And therefore, I think that's a pretty good indication of the legislative intent that our interpretation is correct. Unless there's any further questions.
Any more questions of counsel? Thank you, counsel.
Thank you.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. Our position does rely on Abasolo with respect to the case law aspect of it. I acknowledge in the brief it's certainly not the state's position that the court does not have the discretion to impose or to order the defendant to serve a lesser sentence at a revocation hearing. And I'm not even going to argue that they wouldn't have the discretion to impose a lesser sentence that constitutes a downward durational departure. The issue that was raised by the defendant in the brief essentially was an argument that Judge Kaufman didn't realize that he had the discretion to impose a lesser sentence without making departure findings. Now, I think it's very clear from Judge Kaufman's statement. He knew that he had the discretion to impose a lesser sentence. He talks at length about how he looked for reasons to impose a lesser sentence, and he simply didn't find that any applied. And he specifically said that he did not think that there were any substantial and compelling reasons that would have justified a lesser sentence that took you below the grid to a departure sentence. So he knew that he could impose a lesser sentence. I think the question is, first of all, was he somehow under the mistaken impression that the only lesser sentence that he could impose would be a durational departure, as opposed to simply moving the defendant down to the mitigated number from the standard number? And my response to that is there's no indication that he did not realize he had that ability. In typical cases where the court finds that a district court failed to recognize and thus exercise its discretion, you have a situation where the district court judge makes a statement that shows that he or she is simply not aware that he or she has the option to do something. Judge Kaufman never made that statement here, and it's pure speculation to think that he was unaware of it. I would propose to the court that the reason why he never discussed moving the defendant down to the mitigated number is because that's not what the defendant asked for. The defendant came to the probation hearing and he asked for two things. He asked to be reinstated on probation, and alternatively, he requested that he be given this modified sentence down to 102 months, which would constitute a significant durational departure. So Judge Kaufman was simply addressing the defendant's request, which was, I want a lesser sentence, which would constitute something that would take me below the mitigated number in the grid box. That's where he focused his comments. And when you look at his comments, even though he didn't cite Abasolo by name, it seems fairly clear that that was the case he was referring to. He mentioned a recent case out of Judge Owen's courtroom in which this court had strongly indicated that there would need to be a finding of substantial and compelling reasons in order to justify a sentence that takes you below the grid. Abasolo did come out of Judge Owen's court. It was a recent opinion. I think that it's logical to conclude that that's what he was referring to. I know Mr. Dunn has argued that the language that we're relying on from Abasolo could be considered dicta because this precise question was not presented in that case. But when you look at the language in Abasolo, and this is in large part what the Court of Appeals relied on in this case, there are two separate passages in Abasolo that I think very clearly indicate what this court's position would be with respect to that issue. It specifically stated, neither the statutes nor the case law require a court during a probation violation hearing to set forth reasons for imposing a reduced sentence that does not depart from the presumed sentence under the sentencing guidelines. And later in the opinion, it indicated, moreover, we note that the imposition of the reduced sentence of 36 months would not require the district court to provide reasons on the record for the sentence under the sentencing statutes, as this sentence does not constitute a departure under the guidelines. So while it may be dicta, I would argue that it was a very, very strong indication from this court that in the situation that we have here, that yes, substantial and compelling reasons are required.
How do you factor in McKnight? McKnight was the case where there was 30 months with 24 months post-release, and on probation revocation it was modified to 22 months with no period of post-release. And even though that sentence was illegal, we upheld the modification because it was a lesser sentence.
Well,
I mean, we didn't require that it fit within the guidelines statutes on post-release. So, what I mean, you're saying that departure provisions apply even though post-release provisions don't apply.
I guess that would be, to some extent, my argument. I'm probably not as familiar with McKnight as I should be today. I don't think that it was much of a focus of the defense brief, and so I'm probably not as prepared to answer that as I would prefer to be. I do think that the basic position for the state is that, yes, that Abasolo would seem to indicate very strongly that the departure findings would have been necessitated. And I think that Judge Kaufman, he clearly was up to speed on the law. He had obviously read that opinion, and I would argue that the district court should be able to, in a situation like that, where there might not be a specific opinion out there that addresses this exact question, I think that he did the next most logical thing as he looked at the case law that was present and looked at the strong language from Abasolo, and that suggested that, yes, I will have to make departure findings. So I think that he was attempting to rely on this court's case law, and I would argue that that's something that we should encourage our district court judges to do. The argument as briefed is that Judge Kaufman essentially failed to understand the law and failed to understand what his discretion was. I would submit just the opposite. I think that Judge Kaufman clearly in this case knew the law, understood his discretion, applied it, and simply concluded that there were no substantial and compelling reasons
Was he correct in saying that you have to have different reasons for a durational and dispositional departure? Or different factors?
And that's another issue that wasn't briefed, and so I'm not, again, I don't necessarily have any case law off the top of my head to dispute counsel's argument today. To the contrary, I'll be happy to look at that as I get back to my office. But again, that was not really the issue to any extent. That was not the issue that was raised by counsel. And again, I would explain the fact that Judge Kaufman didn't specify why he was not going to depart or to decrease the sentence to 206 months, which would be the mitigated number, simply because he wasn't asked. And I don't think that it would be fair to suggest that simply because a judge does not address an issue that wasn't prevented before, that's not an indication that the judge didn't realize that he could have done that. He simply wasn't asked to do so by the defendant. I would also argue, as I did in the brief, my policy argument, not surprisingly, would be different than Mr. Dunn's today. And I think the Court of Appeals agreed with the argument that I made, which is that for the sake of uniformity in treating similar defendants in a consistent manner, it would not make sense to say that at a probation violation hearing that there would not be a need for substantial and compelling findings, whereas somebody at sentencing in the first instance would require those. I would argue that just the opposite. Once you've got somebody who not only has gone through sentencing but then has failed on probation, that would even show a greater necessity for departure findings. And with respect to counsel's argument that, well, you might have a situation where a guy goes all the way through and he's just at the finish line and he just slips up and there's a technical violation, and would it really be fair in that situation? My argument to that is those reasons that he provides could be the substantial and compelling reasons. Under the standard that the state is suggesting Abasolo proposes, a defendant in that situation would not be automatically sent up and required to do a sentence or required to do the full sentence. Those could be the exact... If I were a defense attorney in that situation, that would be my argument to the court is, this guy is 99% through with his probation. He made one technical violation. I would argue that it's not appropriate to order him to serve a 216-month sentence, and judge, those are my substantial and compelling reasons for you to find that the sentence, to sentence him below the guidelines is what you should do in this case. So the policy argument that counsel made, I think, maybe sounds good on its face, but when it's applied, I think just the opposite, that somebody that's committed the crime and then given a chance on probation, failed for whatever the reason may be, there should be a requirement that that defendant be able to show substantial and compelling reasons to justify a sentence that goes below the grid sentence.
And shouldn't it be the legislature that makes that policy decision? And here they said, or any lesser sentence, period.
Well,
They didn't say presumptive sentence. They didn't say presumptive or departure sentence. They said, or any lesser sentence. And we've recently been trying to take the legislature at its word that it uses, not what we think it should be.
Sure. I think the response to that is that statute Again, my argument isn't that the legislature didn't give the court the discretion to do that. I clearly acknowledge that the legislature does give the district court the ability, the discretion to impose a lesser sentence, and I'm not suggesting otherwise today. But I do believe that you have to look at that. Probation violation hearings don't happen in a vacuum. There is already a sentence that's been imposed, and so I think it's a little bit of a stretch to suggest that we have to pretend that this has no connection with sentencing and that we shouldn't look at all to the guidance of 2147-16, which is what the Court of Appeals did in this case. And when you read the two statutes together, my argument, the state's argument, is that yes, it does give the court discretion to impose or to order a lesser sentence at the revocation hearing. If that lesser sentence keeps the defendant within the grid box, then the court would not have to make any type of substantial and compelling findings. But if you do go below the mitigated number and impose a durational departure, then is when the duty to make substantial and compelling findings comes into play. And again, in this case, I think the court properly applied Abasolo, recognized that he could have departed but simply found that there were no reasons justifying that, and he was not asked to impose a lesser sentence on the grid. And for that reason, he simply didn't address that aspect of it. But that's by no means an indication that he failed to understand that he had that ability. So I would argue this is not similar to those types of cases where a district court judge makes an affirmative statement indicating a lack of knowledge or a lack of awareness with respect to discretion. For those reasons, if there are no further questions, the state would respectfully request that the district court's decision be affirmed.
Any other questions of counsel? Thank you, counsel.
Thank you.
You reserve 3 minutes for rebuttal.
Thank you, Your Honor. As always, this is probably a mistake. But I think it's pretty important to understand that while counsel says that the district court was probably thinking about Abasolo, Abasolo is not the controlling authority on the subject. The only specific case that was out there by a superior court was State v. Hall that specifically dealt with this issue. And in State v. Hall, the Court of Appeals specifically addressed this issue and said you can give a lesser sentence below the presumptive sentence. In Hall, the defendant had a presumptive sentence, and the court said you can go below that. I don't think it's a proper exercise of discretion to say I'm going to rely on some dicta and think that maybe that's the way things are going to go. But the controlling authority at the time said otherwise. And I was going to talk about policy, but I think we've already covered that basically without rehashing my argument again the first time. I think the plain language of the statute controls
The remedy.
the remedies.
If we agree with you, can we simply send it back to Judge Kaufman and say, apply the correct legal standard?
And unfortunately for Mr. Ardry, Judge Kaufman could say, I don't think I know I can give you a lesser one, but I don't think I want to. And then I think that he would be out of luck there. We would be potentially back. The only issue I could appeal then was, did the court exercise its discretion and abuse its discretion? Would no reasonable person have done that? And I think that would be a much tougher row to hoe, so to speak. But yeah, I think that's exactly the appropriate remedies to go back for reconsideration, properly exercising his discretion.
Any further questions of counsel? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. The court will take this matter under advisement. We now